Well, the clinic is a course designed to allow students to work on actual Supreme Court cases, to get them involved in briefing in the Supreme Court and working hands-on with real cases and complicated issues they present.
They collectively have to look at every single case decided by a state Supreme Court or United States Court of Appeals over the summer. They do all the research, subject to our guidance. They do all the drafting, subject to our supervision. They do all the redrafting. They redraft each other's stuff. We then, towards the end, redraft it. Then they do all the production work on it. Send all the papers off to the printers, and we keep our fingers crossed that the Supreme Court will be interested.
Probably the highlight of the year was a case we worked on called Indiana v. Edwards. The Supreme Court granted cert in that case back in the fall, and oral arguments were heard in that case just this spring. So we spent much of the winter and much of the early spring working on the merits brief in that case.
It's a very interesting case, and it was a very, very engaging argument. The students were fantastic in working on the briefing and in preparing me for oral argument. I did a moot court here with several of the faculty members, and it was extremely helpful and very rewarding process.
Edwards is a case about the Sixth Amendment right to self-representation. Edwards was declared mentally competent to stand trial, but the trial judge found that he was, although competent to stand trial, decided that he was incompetent to represent himself. And we argued that that was a violation of his Sixth Amendment right.
Just after we finished the brief, we started focusing on questions and answers that we could imagine the justices, or questions we could imagine the justices raising. We had the students prepare each at least 10 separate questions they might ask me if they were a justice on the court.
We had done some research into the question of, about pro se litigants and communication problems and how that looked. And so when one of the justices asked a question about that exact issue we had researched, that was incredibly exciting.
The weekly meetings take place on Wednesday nights, at least this year they did, from 4 to 6, 2 hours in the evening. 2 of our professors come to the meetings themselves, and then one works out of New York, and he calls on a speakerphone, which we put in the middle of the table. We call that David, because David is our professor in New York, so David is on the speakerphone. And that's where we talk about issues that need to be talked about and kind of throw out ideas of strategy and talk about more higher stuff at a higher level of abstraction.
We usually divide them up into small teams to start with, because we'll have 4 or 5 cases in the office at the beginning of the year. So we focus maybe 3, 4 people working on a particular case. It's intensely collaborative, but also it's very heavily supervised as well. And I think for them, that kind of experience is wonderful. A few other places you can find it where you have someone from the faculty actually working intensely with 3 or 4 students over a period of weeks to develop something that you can present to the Supreme Court.
Well, they bring a tremendous amount of enthusiasm and aptitude. We've been very lucky. Our students tend to be toward the top of the class, and they're very motivated and eager. They bring that enthusiasm that you have to do this kind of work.
Class can be sometimes such an intellectually trying experience, because you're just being hit with question after question after question to try to establish how are we really going to frame this, how are we going to pitch our side here.
For me, the 2 best things about being a part of it have been the work and the people, not necessarily in that order. The work is fantastic because we are working on real cases in unresolved areas of the law. That has made it also incredibly challenging because there are strong and persuasive arguments on both sides, and our challenge is to find the most persuasive arguments that ultimately hopefully the court will listen to.
So it really gives students a really unique and once in a lifetime for many lawyers opportunity to actually litigate actual cases before the Supreme Court that the court will hear, and gives us a chance to kind of throw around the same issues that the Supreme Court will be dealing with.